Today, let us analyze one more problem in law of torts with regard to the nuisance. That means here in Karnataka State Law University, in question papers, this problem we used to see normally. So this problem always it gets repeated with regard to the concept of nuisance. And you have read with regard to the concept of nuisance. There we can come across there are two kinds of nuisances there. That is public nuisance and the private nuisance. That means you know what is meant by nuisance. Nuisance means generally to do hurt or to annoy some person. Then that means which anything done to the hurt, that is anything done to the hurt, that means HURT, hurt, or annoyance of the land, tenements of another and not amounting a trespass. That means anything which has been caused to annoy some person or hurting some person, either by way of his land or by way of tenements. So there is a clear-cut distinction has been made with regard to the trespass and the nuisance. Here, if anybody, for example, you know, with regard to the digging of the borewells, here what happens, if anybody digs the borewell entire night, that means unpermissible limit of time, causing disturbance to the public and especially to the neighbor person. So it is nothing but causing the annoyance. So here we have to make the distinction with regard to the trespass and the nuisance. So here what I want to put you that here with regard to the problem in law of torts or nuisance, we have to see whether it will come under the public nuisance or which will come under the private nuisance. Here you know this nuisance has also been dealt in Indian Penal Code with regard to the criminal action. So with regard to the civil action, what is the importance of the nuisance? We have to see how far it is creating annoyance or disturbance or causing trouble, either way of causing through it is by annoyance of the land or tenement. So here the certain things are very much important. So it may be the nuisance to property or nuisance to physical comfort. So these things we have to see. And here with regard to the analyzing the nuisance, and you know there are a number of remedies will be provided under the law of torts. That is, it may be abatement, it may be damages, it may be injunction. Abatement means here the plaintiff himself has got the right to ward off the trouble. That means if the neighbor's tree is there, if a neighbor has got the tree and branches has been poked into your property and it is preventing the sun what you call rays. So at the time you can ward off, you can chop off those branches. Here you need not have to go to court. So that will be called as abatement. So likewise, there are a number of remedies are there. That is injunction. You can get the remedy by way of injunction by the court of law. And also you can claim the damages. So this is a very beautiful subject, this nuisance chapter. There we have to come across whether it will fall under the public nuisance or under the private nuisance. Why public and private has been dealt in the law of torts means, here with regard to the public nuisance, the plaintiff has got the little remedy. That means he has got the very what you call the remedy is not it's not there compared to the private nuisance. In private nuisance, as I told you, you got the remedies. It may be abatement, it may be injunction, it may be you can claim the damages. But with regard to the public nuisance, the remedies are different in nature. So here that in order to become the public nuisance, here what we have to see, that nuisance which endanger the safety, comfort and health of the public in general, then we can call it as the public nuisance, and which will also become a crime, and which can be punishable as an offense. So these things we have to remember. And with regard to the private nuisance, what we have to see, we have to prove that there is a what you call the comparable, that is here there should be some special damage has been caused to the plaintiff greater than the damage suffered by the rest of the public. Okay, here I am telling you with regard to the concept with regard to nuisance. However, in the previous my videos, I was telling you with regard to the FIRAC, IRAC and ILAC. Here, FIRAC means, as you know conveniently, that is the facts, issue, rule, analysis and conclusion. Here, I will not repeat these things. Here, in this way, we have to write our we have to solve the problems which has been given in the university examination. That means this is a common internationally approved forum of solving the problems. There are other ways are also there. IRAC, ILAC. IRAC means issue, rule, analysis, conclusion, and other form is ILAC, issue, law, analysis, conclusion. That means here all these patterns are one and the same, but with little differences. But I recommend you follow this FIRAC. That means it will be beautifully, you can write the things, you can beautifully solve the problems. So here how you have to solve this, you have to simplify the facts. Facts would have been given in the question paper. You have to simplify it and you have to frame the issues. And in my previous videos, I told you how to frame the issues. So after framing the issues, you have to search for the provision of law or rule of law or question of fact, question of law. So all those things we have to see under the rule concept. So which is similar to the IRAC, ILAC, that rule, law is same, issue is same, and all the steps are there are same. And further with regard to the analysis, so here in analysis column, we have to deal facts, issue, rule. We have to summarize. We have to see all these facts in hand to hand. That means here we have to see the facts and we have to see the issues, which are the issues will come out of these facts, and which law will be applicable, which provision of law will be applicable. Is there any decided case law is there with regard to the instant cases facts. So all these things we have to see under the analysis section. Then we have to give the conclusion. That normally the students jump into conclusion. And I used to tell you, if anybody jump into conclusion, then it is like seeing the movie from the end. That means from not the beginning, from the end. So likewise it will happen. That means we don't get marks with regard to the, if we jump into the conclusion and if we concentrate only with regard to the conclusion. Okay, most of the students, they're asking for the what you call the salvation of the criminal problems also. For this SEM, you don't have the crime, criminal, IPC you don't have. In the next SEM you are going to have. Let me try to solve those IPC problems also. Let us see the problem with regard to the torts problem. Here it has been given, the plaintiff resided in a house next to a Roman Catholic chapel. Chapel means church, of which the defendant was the priest, and chapel bell was ringing very loudly of all the hours of day and night decide. So in this way, the question has been given in the previous KSLU question papers. So here we have to divide in this way. The plaintiff was residing in a house next to Roman Catholic Church. That is the one fact. That is one thing. We can simplify it. Then what is the next things we can see? The bells of Roman Catholic Church were ringing very loudly day and night. That is the next one. Last one is the defendant was a priest of Roman Catholic Church. That means the in charge of the Roman Catholic chapel or church is the priest. So these are all the facts of the case which has been given in the question paper. We have to see the liability of the priest. So because priest is in charge, and we have to see whether this continuous ringing of the bell will attract any provision of the law under the law of torts. Because in the question paper, they will give the problem. They will not give you from which concept it has been taken. So when you read the concepts, it is very much easier for you to follow the problems. So here I have simplified this problem in this way, and we can frame any issues. I have told you how to frame the issues. With regard to the framing of the issues, with regard to the facts, either you can go for one issue, or if you want to frame more than one issue, you can frame the more issues. Here, out of this problem, we can frame the issues in this way. Here, whether the plaintiff could be able to maintain a civil action. So here you have seen the problem. What are all the problem? How the plaintiff is suffering due to the sound of the ringing of the church bell, and here the plaintiff means the person who resides next to the chapel, who is going to be suffered. So here we have to frame the issues. That is question of law. Here we have to frame the issues in this way: whether the plaintiff could be able to maintain a civil action. That means he is getting suffered by the nuisance. It is a nuisance. It is causing annoyance. It is causing physical discomfort to him, isn't it? So whether the plaintiff could be able to maintain a civil action. So in this way we can frame the issues. And if we could be able to maintain civil action, what sort of the action he has to maintain? If maintainable, what action he could maintain? That is the second issue. And what remedy he could get. That means you can frame the issues according to the facts of the case. That means you got the liberty to frame the issues, but it should be connected with the facts which has been given in the exam, because it should be relevant with regard to the facts. Then only the examiner or the valuer, he will have the interest to look into your problem, how you have shown your legal reasoning capacity, how you are legally, technically, you are drafting the issues, so that you will be a good advocate in future. So these are all the yardstick, these are all the parameters on which it will be decided that you will become you understood the concept, you understood the law concept. So in this way, you can frame the issues, or you can frame in the other way also the issues. But it should be relevant with regard to the facts. Here, I don't want to tell you the other forms of issues. That means how the issues can be framed on the same problem. How different issues can be framed with regard to the same problem. That means whatever it may be, the plaintiff has to get the relief. Either it may be abatement, either it may be injection, or it may be the claiming the damages. Here, this is the facts of the case and issues with regard to the present problem. Then we have to go into the provision of law. Which provision of law will be applicable here? And in law of torts, there are no sections will not be there. In administrative law, law of torts, on certain subjects, we don't find the sections and articles. We have to look into only the concept. Here we can look into the concept which will be applicable is public nuisance and the private nuisance. And there is one case law is there which is of similar in facts of the case which was similar to the problems which has been given in the incident, the problem, that is Solat versus D held. So in that case also same facts of the case we can look into it. So the provision of law applicable is here the public nuisance. It is a matter of public nuisance, and the plaintiff he gets suffered. He suffered a loss or a discomfort, and which was direct and natural, and which is not negligible, and he is suffering a greater damage. more than the other the rest of the public. So here this nuisance will come under the concept of private nuisance. So this is with regard to the provision of law. In exams, we have to write the provision of law. Then we have to analyze all these things. We have to analyze the facts of the case and the issues and the provision of law we have to analyze. So this will be come under the private nuisance, because here the plaintiff he is suffering the greater damage, greater damage, that is suffering the special damage greater than that of the damage suffered by the rest of the public. That means he is the next door to the chapel. So what happens? It is unbearable one, because night and day, that means in the prescribed hours, if the and during certain occasions, if the church bell rings, then there is no problem. If continuously the church bell or chapel bell gets rung all the time, then invariably it will cause the discomfort to the person, that is a plaintiff. So here we can say it is a private nuisance. Here the remedy is what we call, he can ask for the injunction by filing the suit in the civil court. So it is a nuisance to physical comfort. That means he could not, he has got the every right. Plaintiff has got the every right to enjoy his property, isn't it? So here this will come under the private nuisance. So in the conclusion, what you have to write, the defendant could be held liable. Here who is the defendant? The defendant is the priest of the chapel. Here who is the plaintiff? The person who resides next door to the chapel, that is the church. And remedy may be sought for the injunction, as well as damages can also be claimed. So this is the problem we have to come across in the examination with regard to the nuisance concept. So let us discuss the what you call problems, because in law of torts only it is full of the case laws we can find, and very easily you can score the good marks. That is the beauty of this subject, and you can like the subject very much. All the concepts are very beautifully it has been given, and especially if you read the Pandey book, you beautifully you can analyze, you can love to read the concepts. Okay, let us see the next problem in the next video.